Hello everyone, I am Vishwajit Kumar and in today's session we will discuss on Digital Personal Data Protection Act 2023. So before I should start this Digital Personal Data Protection Act 2023. Before starting this, I just want to introduce myself. I am a lawyer by profession, as well as I have more than 15 years of experience in protecting different vertical of IT infrastructure and cybersecurity expert I am, as well as I have provided the data security services also along with the quality control and framing of the different security policies and everything. And somehow I was also part of this Personal Data Protection Act drafting when it was in the drafting stage. So as you know, only few days back, this bill was introduced in Lok Sabha on precisely if we talk on the 3rd August, it was introduced in Lok Sabha and later on it was passed. So today we will start discussing the important provisions of this act. This is not a one day task to understand the act completely. What will be the implication of this act on the IT business, on the IT ecosystem in India, and how the IT companies can cope up with the compliance requirement of this particular act. So everything, all these things we will understand in the video series. So today it will be the introduction to the act where we will see the main provisions of the act. So let's go back to some historical fact how this act came in picture. So I think you guys have heard HIPAA. So that act is in USA. Let me change my marker. So HIPAA is in USA. It is enforced, followed on regularly. Then we have GDPR in EU. So all these provide the data protection framework, compliances, and the law related with different kind of data, different set of data. So apart from these two, data protection, Personal Data Protection Act of India, this is more comprehensive. So what are the main provision? So let's see who are the players. First, so first player is data principal. Data principal, data principal is the main important player. So let's say we will write this DP. DP. DP is a person, legal person, legal person. Okay. Then data fiduciary. Then data fiduciary. Data fiduciary is that person, that company, not person. It is a company. Company who collect data. Company who collect data. So data fiduciary may process the data or take help of data processor. Data processor. So data processor processes data. processes data. But remember one thing, data processor will not collect the data. Data processor don't have authority, or a person who is collecting the data by default, it will become data fiduciary. It will never become a data processor. Data processor will always come after data fiduciary. Okay. So now we have seen these are the player around whom the law is constructed. Then apart from this, there are a few players: DPO, Data Protection Officer, then Consent Manager, CM, Consent Manager. Let me write Consent Manager, then Data Protection Officer. Then apart from this, we have Data Protection Board, which will be constituted under this law. So, this law, let me just give you a gist of what can be the penalty. So, penalty will be in bracket of 50 CR to 250 CR. This is the penalty we are looking at. This is not like IPC or some other regular law of India where penalty is just 5,000, 10,000, something like that. No. Here we are talking about penalties in crores. So minimum is 50 CR and maximum is 250 CR bracket. This is for one instance. Let's say you have paid this fine. Something happened, you have paid this fine. Again, something happens. Again, you paid the fine. After this, the board, data protection board, is free to close down the particular service from where the data is being leaked. Okay, close. Closure of that service will happen. So totally we can say if you have not taken action right now today, you are looking at the big fat fines as well as you are looking at the closure. So this is for all the IT companies. This is pretty mandatory and there is no option, and do not wait for trouble to find you. Once trouble come looking for you, then that day you cannot do anything. Okay. And just say in which scenario. Let's say just simple, we will take example in which scenario. Consider you don't have a data protection capability. Data protection capability. So now this law mandates that when you collect the data, you have data, you need to protect it. If you are not having the capability to protect the data, then your fine, you are looking at the cap of 250 CR. If you are not having the infrastructure to protect your data, mechanism, policy, everything in the place, then you are looking at 250 CR. In case, let's say, still something goes wrong and your data is leaked, then non-reporting of leak. In this case, 200 CR. 200 CR is the fine. Let's say you have some kind of children's data and you have protected everything you have done, but you are sending a targeted advertisement to that children on basis of their behavioral monitoring. So children, just I will write children, that you are looking at 200 CR. You have protected the data. You have protected the data. What you are just doing, you are tracking the children's behavior, tracking them, analyzing how they are doing, and then you are publishing targeted advertisement. Same way, like just say we go to some e-commerce website and today I am just browsing for mobile phones. Next, what happens if I go to any website where the advertisements are enabled? I automatically get the advertisement for different mobile phones. That is targeted advertisement. Now, being an adult, if it is targeted to me, general practice, okay, no problem. But in case you are sending a targeted advertisement to a children, then you are looking at 200 CI fine. Simple, neat and clean. And any provision of this act, if you are not following, then you are looking at 50 CI. Apart from there are 5, 6 heads of the fines. If you are not falling under that, still you are violating any provision of this act, then you are looking at the 50 CI fine. So now let's say how this act mandate us mandate the IT ecosystem to follow a procedure of data collection. Okay, how that will happen? Let's see. Now, data collection. How data collection will happen? So first, you have to ask for consent. Consent. So every IT company, whoever is watching this video, share with your other known person, teammates, other person in other companies whom really you want to understand this and get protected before they go into the fine and all. So if you just care about them, spread this uh, video, spread my words, let them know what they are going to deal with. Okay, this is not like something I'm just educating on some different topic. Okay, you learned, someone else forgot, nothing will happen. They can learn from somewhere. There are very less information available on Personal Data Protection Act right now. So as much as you will share, people will know how to deal with this act, and they will not they will not have to appear in front of the data protection board and pay the fine. Okay, so these things we have to see now how the data collection will work. Okay, now the consent has neat and clean mentioned clear instructions how to take consent. So in the consent, whenever you are going to collect any data, about to collect data, let's say someone is visiting your website, and on the website you are giving some report. Okay, I will provide you some report of different quality of a product, or some kind of report. Or let's say cybersecurity roadmap, cybersecurity scenario of in market in India, these kind of anything. And before downloading that document, you have to provide your mail ID, you have to provide your name, phone number, organization name, official mail ID, all these things. This is data collection. Okay. When you are going to collect data, that time you have to ask for consent. Consent should be very neat and clean, clear, crisp. It should mention what is the purpose. What is the purpose of consent? What is the data being collected? Okay, and then who is the data protection officer or some designated person from the company who will look into the grievances, who will see if any complaints are made on this scenario. then then consent manager, this consent manager will be a person who is qualified and registered with Data Protection Board. Okay. So when you are taking the service of a consent manager, that consent manager come in picture. So their contact detail. Okay. Then Data Protection Board of India. They how to make complaint. Okay, if someone wants to go to Data Protection Board of India, how to make a complaint, what will be the mechanism? This you have to mention in the consent. Okay, and then you can, or purpose, it should be legal. The purpose should be legal. For any purpose which is not in line with this particular act or any act presently in India, okay, or violate the constitutional provisions of India, like fundamental right, fundamental duty, anything, any violation, anything which is violating, that will become illegal. Your consent, if someone is giving consent on that also, then it is null and void. Just say, for example, a company which is from the US, okay, and that company have operation in India also, but their head office is in US. Now they are collecting the Indian citizen data in India, and what they are saying in consent, any legal issue arising from this consent will be subject to be handled in court of New York. And recently, in one decision, High Court of Kerala clearly said if there is any contract which enforces the citizen of India to go to any court outside India and the service is rendered in India, then that particular part of the agreement is invalid. Okay, any company cannot force you to file a case against them if say anything goes wrong in any court out of India. So that provision is there as per the contract also, and as per the guideline of High Court, Kerala High Court. So if they say that, that is illegal. If you give the if any user gives the consent over that also, that consent is null and void. So you have to be very careful while taking the consent. Then consent withdrawal. Consent withdrawal is the mechanism where user or the person or data principal have the option to withdraw their consent. Okay, the company has to provide a mechanism for that, as well as the data modification. Whatever data a company have collected, if user want to see what data is there, how they, what kind of utilization the company who collected the data they have, let's say data fiduciary, what uses data fiduciary have of the data, how they are using it. So everything should be visible to the user who have provided you the data. Okay. So the data principal, they must have option to withdraw their consent. And remember one thing: once they withdraw their consent, you cannot use their data. There is one more thing. Yeah, I will give you an example. Person A, person A goes to a second-hand car company, and person A says, "I need a car." Let's say they need a BMW. Okay, BMW, some particular model, they have explained this is the condition. I want a second-hand car, which is in good condition, this price range. Company says, okay, well and good. We will provide, we will look for the BMW and we will provide you. Now, in company, they got one BMW. They called user, they sent the photos on the WhatsApp and everything. And user saw that car and user said, no, 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 I do not want that car. Somehow passes and it is now 3 months. After 3 months, there was one car. Company sent the details to user. User A, he just saw that car and he said, "Okay, yes, I'm going to buy this car." So as soon as A buys that car company has to remove the data without this consent withdrawal, because the purpose is fulfilled. The purpose for which data is collected, consent is given, that purpose is fulfilled. So the company has to remove the data. If they are not removing the data, fine, simple. There is no way around of that. So they have to remove the data. Okay. So now you understood the consent, you understand the consent withdrawal. Consent withdrawal, there is one more case, let me explain to you. Just say there is a e-commerce website. Now e-commerce website, user A registered to website, then for the buying different product. User A is buying, user A purchased a phone, and phone is dispatched from that e-commerce website. Payment is made by the user A. But once user A made the payment, immediately user A goes to the consent withdrawal and withdraw the consent from that website. I do not want to give you consent to use the data anymore. Now that company cannot stop the shipment because payment is made, purchase is done. So shipment cannot be stopped. Company has to send the phone to person A's address, and once this transaction is closed, they have to remove the data. They cannot say, okay, you have withdrawn the consent, we will not send you the phone. No, they cannot do that. They have to send the phone. Once they send the phone is delivered to that person. That means that particular purchase transaction is closed. Data principal have received the item, data fiduciary have received the payment. So both parties have received their considerations. Once considerations are met, then it is closed. They have to remove the data. Okay. So let's move to now consent. Consent withdrawal is done. There, one more thing I want to address. Uh, in consent, there is something like legal usage, legal use. Let's say I'm just explaining you by the example because sometimes it is easy to explain the things by example. I do not expect everyone to be a lawyer here, whoever is listening to this video, or my targeted audience are the CISO, CIOs, and IT managers who are sitting in the corporate offices of a company, enterprises, SMB, or different segments are there. I do not expect them to be a lawyer, law expert. So, in the layman term, I'm just explaining to you. Let's say a person A goes to a shop, so let's say medicine shop, and person A purchases some medicine, and person A asks that shop owner, please send the bill to my number. Then person A gives number to shop owner. At that time, shop owner does not need consent because person A is providing to shop owner his mobile number for the bill. Shop owner, as soon as shop owner becomes a data fiduciary, as soon as data fiduciary sends the bill to person A, who is the data principal, then after that their transaction is done. Data fiduciary should not keep the mobile number with them any longer. Yes, if person A, data principal, says, I will use this mobile number, I will send whatever medicine I need, I will send you a message on WhatsApp. And after that, then you provide me the medicine, you deliver to my home, something like that. If something happens like this and sends a message on WhatsApp saying hi, the shopkeeper said, please send me hi. Okay, and your name, so I will save down your number. In that way, what happens? The consent is given. Okay, this is considered consent is given. Same way it happens with government organization, who is collecting the data for different purposes. It is mentioned in the law itself that like issuance of driving license, some permit, or giving you the subsidy, something, some benefit, all these kind of activities when government is providing, government is collecting the data from you. That means the government do not need consent at that point of time. Okay, and government, there are multiple use for any legal purpose, for security of country, for a health purpose, for any disaster recovery scenario. All the in these scenario, government is free to use the data, but there is no provision in this act given which excludes government from data theft, data loss, or not protecting the data. The 200 CI, what fine I have explained, when you are not, sorry, 250 CI, when you are not able to protect the data, you do not have the data mechanism, data protection mechanism, 250 CI. There is no exclusion for government on that part. Government government organizations are only excluded in how they are going to give the consent, how they are using the data, but they have to implement the data protection mechanism at their offices, wherever they are storing the data. Okay. And if they are outsourcing it to data processor, a third party who is responsible to process data on behalf of data fiduciary. In that case also, responsibility lies with data fiduciary to safeguard the data. Second point, data breach reporting. There is no exclusion on that part also. When data breach happens, you have to report to each and every individual whose data has been breached. Okay. And then you have to report the data protection board also. So if you have failed to report, 200 CI, simple. So it is all game of 250 CI, 200 CI, 150 CI, and 50 CI. So whatever you do, you go wrong against this law, there is penalty. That penalty is very severe. And I am 100% sure nobody wants to take responsibility of that penalty in the IT ecosystem, because board of director is not responsible towards the safeguard of the data of company. Okay, it is a responsibility of the CTOs, CIOs, CSOs. So their responsibility it is to run the IT operation, to safeguard the data. If they are not able to safeguard the data, you can understand what will happen with them. If the company is paying 250 CI fine to the government, blame will go on which party, you can understand. And my friend, he asked me on the compensation part. Compensation part. Will the user will get compensated? Whose data is violated, user will get compensated. So this law added for section 43A of IT Act. Section 43A says if someone by the act of data theft or data leak or data misusing something in these activity related to data, someone gains undue advantage or someone causes loss to some other person whose data had been leaked, theft, or anything violated. In that case, compensation will be given to that person. But there should be some kind of loss that person has to data principal. Data principal has to prove there was a loss. Okay, and on that basis, and easily when this is law, you are violating a law, you may attract criminal charges also. So being an IT manager, being a CTO, CISO, general manager, I don't think you want to attract any criminal charges. You do not want any IPC section to be added to this, because there are many sections in IPC which deals with like breach of trust, theft, loss, sabotage. There are many things. Okay, and then it relies on the different law. Okay, if that law says there is a breach of trust, then we will consider it breach of trust. So this law says you have breached the trust, you lost the data user have given you. Now IPC will say, okay, I will also come in picture. So then it will become civil plus criminal. It will become both. So there maybe you will be visiting two courts, one court created by the Data Protection Board of India. Then second you will go to criminal court, session court, which is. So these kind of things can happen. So we have to take this law very seriously. And then we have to look into the compliance part, how to get compliant, how to implement these things. Okay, so now compensation we have talked, data collection we have talked. After data collection, it becomes data protection. Section 8 clearly says when you are collecting the data, you need to protect that data. Okay, then data usage. There are various guidelines, not guidelines as per se, various rules, various law. It is given on how you are going to use the data. This is separated to adult and to child, child plus disabled. Okay. Child plus disabled. So they are in altogether we can say the age group, the person group which needs a guardian or parent. They fall under this, and this is the which do not need any guardian or parent for giving the consent. Okay, they as per the law in India, they are old enough to give the consent. They will go into adult part. As per law in India, those who cannot give the consent, they will go into this part. Okay, so data usage is different for both. Adult, you can send a targeted message, all these things you can do, and but this child you cannot send, you cannot do that, you cannot manipulate. You cannot cause any harm to child in the way of manipulation of their data, way of decision making. So you cannot cause any harm. That is 200 CI. So remember. So data usage. Now data retention. If any law specifically instruct you to retain the data of a data principal, then only you can retain the data. Otherwise, you cannot retain the data without the consent or when the usage for that data, when purpose of collecting that data is fulfilled, you cannot retain that data. Simple way. So now you will say, in which case I can retain the data? Again, I will give you an example. Just say user A. Now user A is like opened a bank account, and let's say I will give you an example of opening. There is a bank, XYG Bank is there. XYG Bank has its own mobile app. XYG Bank says it is easy, no need to visit the branch. Open your account on the mobile app, upload all the KYC document, give the video like video KYC, do all these things, your account will be opened. But when installing the app, then they ask for the permission to your contact details. In your contact list, all the contacts are there. They need permission. Okay, you said okay. But they don't have any use of that contact list. If they have the UPI or where the contact list is used, then it's fine. They are taking the consent. But if their app does not have UPI feature or some kind these kind of things, then it is not fine. And if without being fine, they just go and use the contact list from your phone, they are violating this law. Okay, you got my point. Now your account is open. User A's account has been opened. For next 6 months, user A uses that account, and after that, user A says, "No, please close this account." So after closure of account, also the bank will retain the KYC data or personal data of that user because there is a law which says bank has to retain the data for 10 years of any user which account is closed. So by the law, bank is empowered to retain the data. But in other cases, there will be no data retention. Okay. Now we have seen DPO, Data Protection Officer. The role of DPO will be very significant. DPO will report to Board of Directors. DPO will not report to CISO, CTO, CISO, anyone. DPO's reporting will be directly to board of directors. Okay. DPO will give the guideline on how to protect the data. DPO will also ensure he or she is continuously monitoring the protection mechanism of data, consent, withdrawal, grievance, everything DPO has to monitor. Then there will be third party independent auditors audit on the given frequency by the data protection board. So board says in 3 months you have to get the third party audit. So company has to get the third party audit. Okay. So in that audit, maybe board will give you the time to fulfill the gap or re-audit or these kind of mechanism. It will come in picture very soon. So when that mechanism comes for the audit, then DPO will get involved and the DPO will assure. Sorry, let me drink some water. So DPO is single point of contact for board. DPO will represent the company to the board and single point of contact when board is trying to communicate to company. Board will communicate to DPO. Okay. And any grievance redressal, any from the user side, any grievance come, no, you are using the data in a wrong way, then DPO has to address that redressal, do the redressal of that grievance. So DPO's role is very premium kind of. DPO, every big data fiduciary, and there is one like classification of data fiduciary which is called significant data fiduciary. So government will give a guideline on that part who will be kind of significant data fiduciary. But as for now, we can understand those companies which have very large amount of data. Those companies which process sensitive kind of data, sensitive to the security of nation, health of the person, sensitive to the children, or all these kind of things, those company which is doing, they will call it a significant data fiduciary. Now, significant data fiduciary have some different set of obligations, additional to the obligation given for any data fiduciary. In coming videos, we will see one by one. We will open the act itself. We will see one by one. What else today? It is more about the introduction. You have to understand what is coming to you, what kind of trouble you may get into, what kind of law is coming towards you, and how to get ready. Okay, and obviously to promote my knowledge. So you can contact me, you can ask me questions and get clarity on how your organization is planning for this. I can help you validate your points. All these, my details will be there soon in the video. So you can contact me, email me. There, I don't think I need to explain. All the mechanism, today's mechanism, communication mechanism, it is known to you. Okay. So now we have seen the DPO, consent manager. So it is not like you should have a DPO as well as consent manager. No, it is not like that. What government is thinking? Let's say. So consent manager is someone impaneled with the board. The board will identify some IT person who have the knowledge of law also, or IT also. Okay, and I will give the training for CMDPO also. So in that you can get trained how the law is going to affect. And just remember one thing: when any litigation is made, charge sheet is filed, it is not like only one law. Okay, there are multiple vertical of law we have to look into the, like contract act, we have to look into the PDP act, we have to look into the IPC, we have to look into the CIPC, CPC, okay, civil procedures. So all these things we have to look into and then only a litigation will go on. That's how we will go into the court to defend any of the person. So these things I will give you a training. What are the essential items? How you can do your role as a DPO, you can your role as a CM. Then once it is published by the board, okay, so this is the mechanism to become the um, consent manager. Then I will guide you to that also, so you can easily get registered to the data protection board. So all these things I will do. Okay, no worries on that part. So as well as this is for the person who is planning to become a DPO or a CM. So you will understand each and everything clearly, no issues in that. So CM mostly with a smaller organization who cannot afford a DPO, who cannot employ a large, very well paid person or something like that, then they can avail the service of the CM, okay, consent manager. But significant data fiduciary, whenever government is classifying you as a significant data fiduciary, then you have to go for a DPO. Then you cannot go for a CM. Okay. Yes. In addition, CM can do the consent management. Some CM can work with DPO. That is not at all a problem. But you should have a DPO in the place. I explained in the case of large fiduciary how the DPO will work. Now, next point comes, what are the obligations? Okay. There are a set of obligations of data fiduciary. There are a set of obligations for the data principal. So those obligations are, well, most over you can say it is around how you have to safeguard the data in case of breach, how you have to report the breach. So obligations are almost around that. Now let's consider some practical scenario. We are studying theory too much. Let's say some practical scenario. Now I will come to a part of IT company. Okay, so any IT company, I think my markers are getting old. There is a IT company. In today's scenario, any enterprises level IT company, they have everything. It is not like they do not have. They have like IT infra. They can protect the gateway. Let's not dwell onto the marker issue. Uh, Proceed our discussion. So what happens? IT company, they have everything. They have the PIM, PAM, they can do the privilege management, they have the gateway security, they have like sandboxing solution to attack, to like stop any attack. They have honeypot to divert any attack. They have like a different kind of SIM, XDI, all these facilities they have. Many things they have. But do they have mechanism to identify if data breach happened? Because someone stole the data. What data they stole? You do not know. You may have identified, okay, someone stole the data. Or your internal user. He has the privilege, everything he has. Then internal user, what he does, he does the theft of data. You do not know who have done what. Or let's say there is a case. There is a case someone have just mimicked your website, your domain. Just say a company is xab.com. My apologies if xab is a real name of some company. I do not know. Okay, so that's why I am using anything. It can be x star star. Let's say this. This is the name of a company.com. Now what I did, I duplicated a website. I started collecting data on this duplicate website, but they are not able to identify this. The person, data principal who is giving the data, they will know I have given data to this company. They are under impression I am giving data to this company. Then again, you become indirectly liable because you are not able to safeguard your domain itself. You are not able to provide a safe environment. to the user. Okay, so these cases will go indirect way. It is not a direct offense, it will go in indirect offense, but still it may be offense. Now, say, so what you have to do? You have to protect your brand. You have to protect your domain. That you have to take care that no one copies your domain name or mimicking the domain name or creating a false look-alike website, same looking like your website or something like that. You have to keep digging for that. Also, if data goes into the darknet, deep web, somewhere your data goes, how you will know? So you need to keep monitoring that also. Anytime, anywhere, when you see the data related to user data, what you have pops up somewhere else, immediately you need to report. This is the data breach. In that way, you may protect yourself from the litigation, from the fine. You may, that there is a word may, but still you have a good chance. In good faith, you are reporting that. Okay, so law also give weightage to good faith. So when you are reporting, so be ready for the mechanism to trace out your data. Wherever your data is getting leaked, what is happening, you must be able to trace out. If you are not able to trace out, remember this 200 CI. I am sure if today I try to find out the cost service for all these, it will not cost more than 1 CI, 1.5 CI, but let's say 2 CI. But almost 100 times is the fine you will be charged. So be careful on these parts. Protect as well as, like there is a saying, uh, hope for the best and prepare for the worst. Okay, so prepare for the worst because that is 250 CI fine, and hope for the best because that is 200 CI fine. Okay, only difference is 50 CI, and there may be different offense also. So you will not want to go into those offense. Okay, charged with those offenses. So we have taken the example of a IT company which have or IT environment, any banking, any BFSI segment, retail segment. So these are more vulnerable. BFSI, they have lots of data. Retail, they have lots of tons of data. Okay. Aviation also, they collect all the data. And then there are many education. Education is like so many children's data they have. So much of children's data they have. Anything leaked, 200 CR direct. Not leaked even. Not leaked. They are giving the advertisement on basis of behavior of child, 200 CR. Simple. So lots of tons of fine. Okay. So now get ready, get moving. Okay. Try to understand incoming like videos. I will take out the your act completely, go through it line by line. I will explain you how this is going to affect, how this is going to work. I have also prepared the checklist, audit checklist, how you are going to audit for a PDP Act. That you may take from me, audit checklist, send me a message or mail, or I will share the checklist with you. So you can go through that checklist. And remember, we are talking legal. Sharing video is not illegal, but sharing any one-to-one data is still illegal. Okay. So whenever you need, ask me directly. Ask me to provide you data. I will give you the data that is free of cost. There is no charge on that. So don't worry on that part. Freely just ask me. You will get the checklist, any guidance you will get on that. No worries on that part. Okay. So now let's conclude today's session and we will meet in next session. And I am utilizing eTuition's platform. Let me tell you something about eTuition. eTuition is a platform where students fulfill their needs of education and students. I'm not talking about just kids. I'm talking about adult student also, like if you want to learn a language, learn programming language, foreign language, something like that you want to do, you can come to eTuition platform, you can learn. And for kids, there are so many things, academics as well as non-academics, painting you want to learn, guitar you want to learn. So eTuition is a platform which brings all the best teachers to one platform. There will students coming to this platform. They together go for a tuition, one-to-one tuition to understand, to learn something different. Okay, and I am Viswajit Kumar. I'm part of the e-tuition. I'm also a lawyer. I'm giving you the detail on DPDP 2023. Today we will continue this, and there are many more videos I have on this platform, so you can watch those also. Maybe for the IT guys, that is not relevant because that is more of the academic part, competition related, all those things. So for the IT guys, this is very, very, very relevant. Especially guys on senior position, your life now depends upon this. This is not something to take easy. It is almost about your living, your job, your life. Okay. So get ready, get in touch with me, like this video, also subscribe. So next videos, you do not have to look for my videos. Once you have subscribed and press the bell icon, I will put the video, you will get the alert. You can look into that video. Okay. And spread my words to other of your colleagues in other organization also. So they will come to know what is going on, what is the new thing, what are the changes, all these things. And do not hesitate to put your thoughts on the comment. If somewhere I'm somewhere maybe some spelling mistake is there, you can highlight. I will take it a good feedback. There is nothing. You want to talk to me, my contact will be there, email IDs will be there. You can reach to me. I'm trying to just help this industry because I'm also part of this industry. Okay, and mutual help will take us a long way. So no need to worry. So for today, namaste and goodbye. We will meet soon. Thank you so much.